How does surrogacy work in the context of UK immigration and British nationality law? My name is Keelin Claffey and I'm a solicitor at Latitude Law, here to talk to you about surrogacy and UK immigration. Surrogacy in the context of immigration law can be a very complex topic and will usually require legal advice if you are considering having a child via a surrogate. Surrogacy arrangements are not enforceable in the UK under the Surrogacy Arrangements Acts of 1985, which means many people will enter into an arrangement with an overseas surrogate mother. In the UK, the intended parents of a child born to a surrogate mother do not become the legal parents of a child until a parental order is granted by the Central Family Court. The making of this order extinguishes the rights of a surrogate mother and any spouse she may have. In order to obtain a parental order, the gametes, meaning the DNA, of at least one of the intended parents must have been used to create the embryo. Where no gametes were used by the intended parents to create the embryo, then this would require a legal adoption to take place before the intended parents could be recognized as the legal parents of the child. Importantly, the Central Family Court in the UK cannot make a parental order in favour of the intended parents unless they and the child are all physically present in the UK, which can present challenges with regard to bringing a child to the UK from overseas. In UK family law and in British nationality law, the mother of the child is always the woman who gives birth to the child, regardless of whether she has any genetic relationship to the child. The father of the child is either the surrogate mother's spouse, if she is married, or if she is unmarried, then the child's father is a man who can be proven as that child's biological father. The position is different in UK immigration law in that the parents of a child are both the biological parents and their legal parents, which would include a surrogate mother and or her spouse or civil partner until the making of the parental order by the Central Family Court. This means that under UK immigration law, children can effectively have 4 different people recognised as their parents. Children born abroad to a surrogate may acquire British nationality automatically at birth, depending on the nationality of the surrogate mother and either her spouse or the biological father of the child. Otherwise, children will acquire British nationality automatically on the making of a parental order if at least one of the parents is a British citizen at the time the order is made. There is also scope to get children born to surrogate mothers registered as a British citizen by either discretion or entitlement, but these applications are not always straightforward. It is also possible to bring children born abroad to the UK under various provisions of the UK's immigration rules, and rarely applications for leave outside of the immigration rules can also be made. It can be tricky to decide which option is the best and often the quickest route to bring children to the UK, so specialist advice should be sought if you are unsure. If you have any questions about surrogacy in the context of UK immigration or British nationality law, please contact Latitude Law to find out how we can help you.